listen-only mode.
Hello and welcome to the 53rd Bi-Monthly Breastfeeding Coalition's webinar. I'm Kinkini Banerjee, the Coalition's Relations Manager at USBC, and I'm so glad to have you join us today. This series is jointly hosted by CDC's Division of Nutrition, Physical Activity and Obesity and by the USBC. The webinars referred to as the 222 are held on the second Tuesdays of even-numbered months from 2 to 3 p.m. Eastern. And the purpose of this series is to bring together breastfeeding coalitions to share best practices and news and to network and collaborate on issues of national significance. We alternate the sessions, so we bring you highlights from national organizations and from state and local coalition initiatives. In May, you heard Gail Watley from the Alabama Breastfeeding Committee speak about how their coalition found synergies from their various funded projects to coordinate breastfeeding support initiatives along with multiple stakeholders. The coalition members and breastfeeding advocates from around the country can join us for these free webinars. Join the coalition's Learning Connection to get all our announcements. The topic and speaker details are posted 2 weeks before each webinar on a page on the USBC public website, www.usbreastfeeding.org/coalitionswebinar, and also on the Coalition Learning Connection. To streamline access, since April, we've now set up the webinars as a series. So if you register for one, you're automatically registered for the full series. And you don't need to, even though you may not be able to attend every session live, the series registration will allow you to get the handouts, the links, and all the other information about the archived recordings. Following this session, the regions will break out for their regional meetings that is conducted over the phone. And please contact your coalition to learn how participation in the regional calls is arranged in your coalition. The webinar presentations and video recordings of this and past sessions can be found on the coalition's webinar page. You can either get that info on your confirmation emails or go to our website, and I'll show you where it is. So on our website, along the tabs, the last one is the one on coalitions. Just click on it and it'll open up a whole bunch of different menus, and scroll down to the one that says CDC-USBC bi-monthly webinars, and that's where you can access the handout from today's webinar as well as our past webinar recordings. For today's session, all participants are in listen-only mode. We set 10 minutes for question and answers at the end of the presentation, and you can type your questions at any time during the webinar, and here's how you do it. On the right side of your screen, you should see a control panel. If you don't see it, it may have been minimized. Just click on that orange tab with a white arrow and it'll pop back out. Scroll down the tabs till you see a tab for questions. Click on that on questions and it'll open up a text box for you to type in. If you have any webinar-related tech problems, please send an email to coalitions@usbreastfeeding.org, and our staff will do their best to help you. And that brings me to today's session: freedom of expression, legal protections for nursing mothers at work. The federal break time for nursing mothers law requires employers to provide time and space for breastfeeding employees to express breast milk during the workday. And as many of you coalitions are from states that also have state legislation requiring workplace lactation accommodations. When both the federal and state governments address the same situation, the stronger law applies. This means that if a state has a workplace breastfeeding law, the stronger components of the state law will overrule the federal law where it provides a greater protection for employees. So during today's session, you will hear about the legal protections related to pumping at work so we can support mothers in exercising their rights. And I am delighted to introduce our presenter, Galen Sherwin. Galen is a senior staff attorney at the Women's Rights Projects of the American Civil Liberties Union, where she works primarily on equality for women and girls in education and employment, with a focus on sex stereotypes and discrimination on the basis of pregnancy and breastfeeding. Galen joined the ACLU after 4 years with the New York Civil Liberties Union, where she was director of the Reproductive Rights Project. Prior to joining the ACLU family, Galen was a Blackman Fellow in the Domestic Legal Program of the Center for Reproductive Rights and a law clerk to Judge Jared Lynch, then from the Southern District of New York. She graduated from Columbia Law School and Yale University, and Galen will share with us info about the ACLU's Women's Rights Project and their work on breastfeeding rights. And with that, I'm going to turn it over to Galen. Welcome, Galen.
Thank you so much, Kinkini. I'm just going to turn on my screen so folks can hopefully see it.
Yes, we do.
Here? Okay, great. So thank you all so much for inviting me to present on this webinar. I've been working on breastfeeding rights for much of my legal career, even before I personally breastfed my 2 children, so this is an issue that is very near and dear to my heart. I'm going to start by talking a little bit about the goals of the webinar. I'm hoping that I will be arming you with some information about the legal protections for women that are related to pumping at work so that you can better support women in exercising their rights. I know that the providers and advocates on this call are critical points of connection for women, not only to the medical profession, where unfortunately breastfeeding issues can sometimes fall through the cracks, but also to other supportive services, including advocacy opportunities and legal help. And I'm hoping that I'll be able to arm you with some general legal information so that you can do that better. However, here's my disclaimer. I'm giving this webinar for educational purposes only, so it doesn't constitute legal advice, and my goal is not to equip you to provide legal advice. Anybody seeking legal advice or who has a legal problem needs to consult an attorney who's familiar with their own specific circumstances. In the process of speaking with you today, I'm going to start by telling you a little bit about the ACLU, just give you an introduction to what it does, and I'm going to give you a very general overview of the law, including discussing the source of the legal protections that I'll be talking about, what they do and don't do, and what the options are when employers don't comply with the law. And finally, I'll point you to some strategies and resources that I hope will help women advocate for themselves, and also give you some ideas for organizations that you could connect women to when they need further help. So first, a short introduction to the ACLU in general and the Women's Rights Project in particular. The ACLU is a legal organization, a public interest legal organization nationwide. We have affiliates in every state, and our purpose is to defend the Constitution and the Bill of Rights. The Women's Rights Project of the ACLU was founded in 1972 by Ruth Bader Ginsburg, before she was, of course, a Supreme Court Justice. We have 3 areas of focus currently: workplace rights, ending gender-based violence, and securing equal rights in education for women and girls. And obviously the work I'm talking to you today about falls under the workplace rights umbrella of our work. We do our work through a combination of different tactics. We use advocacy and public education. We do legislative and policy work, and then we also, of course, do litigation representing individuals and organizations in lawsuits. The picture on this screen is actually a good example of some of our advocacy work. This was an advocacy campaign. We did a petition to get the Texas Board of Law Examiners to change its policies and permit nursing mothers to apply for testing accommodations so that they could pump during the 8-hour bar exam. And we ended up getting over 25,000 signatures, and they changed their policy. So we use our platforms very broadly to try and affect change. Our work on employment focuses on 3 areas: equal pay for women in non-traditional fields, and then pregnancy discrimination broadly. And within pregnancy discrimination, we focus on pregnancy accommodations and discrimination against women on the basis of stereotypes about their roles as caregivers. We've also really focused heavily on the point at which women first return to work after having babies, when the challenges of balancing motherhood with work can be the most difficult. We found that this is a flashpoint when women frequently face discrimination, either overt or more structural. And breastfeeding and requests for accommodations related to breastfeeding can often trigger or surface those types of discrimination. And I'll give some examples of what that looks like in a few minutes. But first, I want to move to the overview of the legal protections that are in place for women to protect their rights at work. So I've divided the types of protections into two categories. The first category I'm calling right to pump laws, and the second category is anti-discrimination protections, and that's the one that I feel that I suspect the folks on this call are less likely to be familiar with. So on the right to pump laws, these place an affirmative obligation on employers to provide accommodations for breastfeeding and pumping, and there are two main sources of these obligations. The first, as I'm sure you know, is the Reasonable Break Time for Nursing Mothers provision, which was enacted as a part of the Patient Protection and Affordable Care Act, and is located in a much longer and more complicated law called the Fair Labor Standards Act. I'm going to refer to that law as the Nursing Mothers Act, just as shorthand going forward. And then there are state laws, as Kinkini mentioned in the introduction, that do essentially the same thing, but they may differ in scope or other respects. And then under the category of anti-discrimination protections, this is a category of laws that prohibit employment discrimination on the basis of sex and other protected characteristics, including race, color, religion, national origin, disability. The sex discrimination protection included in these includes pregnancy and related conditions like lactation, and I will discuss that more in a minute. These types of laws operate at both the federal and state level. The federal law is known as Title VII of the Civil Rights Act. I'll refer to that as Title VII going forward. And as I mentioned, it also covers other forms of discrimination. So first, a little bit of detail about the Nursing Mothers Act. It's the most well-known protection for lactation currently. I hope you all have heard of it by now. I do want to give you a little more detail. Forgive me if it's going over ground that you already know, but I think it's important to reiterate and make sure that we're all on the same page. So the first thing is, who does the Nursing Mothers Act cover? The first main category to understand is because it is located in the Fair Labor Standards Act, which is a protection for working conditions for workers, the Nursing Mothers Act itself only applies to non-exempt employees, that is, employees who are not exempt from the wage and overtime protections of that Fair Labor Standards Act, that larger law. So that unfortunately leaves quite a few people not covered by its protections. The general rule is that salaried workers are not covered, although there are even exceptions to that, particularly for lower wage workers. But it does not cover the terms that the law uses are executive employees, administrative employees, and professional employees as three categories. Exactly what that means can be difficult to understand. So I basically, if you have any questions about whether somebody is covered, if they don't know whether they're an exempt employee or not, then there's actually a really helpful resource which is listed at the bottom of this page. It's the Fair Labor Standards Act Advisor, and you can go on there and actually take a little bit of a quiz. They walk you through the questions to find out whether the employee is covered or not covered. There are two ways of establishing coverage by the Fair Labor Standards Act. The first is known as enterprise coverage, and that means that if the business has at least 2 employees and at least $50,000 in revenue, then every non-exempt employee at that place of work is going to be covered. The second way of establishing coverage is through individual coverage. That means that even if the business in question, the employer in question, does not meet the categories in number 1 of the revenue generating requirement and then the number of employees, individuals who engage in interstate commerce and who are not exempt, that don't fall into one of the exempt categories under the Fair Labor Standards Act, are covered. So and that is interpreted quite broadly. So the types of activity that can bring you under the protection of the Fair Labor Standards Act and that count as engaging in interstate commerce include things like placing phone calls across state lines or mailing letters to other states, processing credit card transactions, or handling goods manufactured in interstate commerce, shipping anything in interstate commerce routinely as a part of your work duties. So that is a good way to get people swept under the protection of the law, even if the entire business is not otherwise covered. So what does the substance of the Nursing Mothers Act entail? What does the reasonable break time provision require? It requires that employers provide breaks each time the employee has a need to pump. Now, there's some guidance on what that means that the Department of Labor has put out. It has stated that that will typically mean that a woman will need to pump 2 to 3 times during an 8-hour workday, but at the same time, the department recognizes that both the frequency of the need for pumping breaks and the duration of the pumping breaks will vary for individual women based on a host of factors. So that's an important thing to note, and that each time the employee has a need to pump really means that it's based on that individual woman's individual circumstances. And then the other thing to note is that employers are required to take into account the entire time it takes for the process, including the time to set up and break down and clean the equipment, and then take into account factors such as the proximity of the pumping facility, the breast pumping facility, to the person's workstation, the access to running water and a place to clean the equipment, as well as the access to the place to store the milk. So all of those factors are supposed to be taken into account when determining how long of a break the women will need when they request the time. Some other requirements, obviously the law specifies explicitly that the location cannot be a bathroom. I'll note, however, that in certain circumstances, a room that is attached to a bathroom, like an anteroom, may be appropriate as long as it also meets the other requirements of the law, and those include that the location be shielded from view and free from intrusion by coworkers and the public. I'll mention that multi-purpose spaces may be permitted. So, for example, in a small workplace, the office may designate a particular room or office that is used for other purposes, but that it is closed off to those purposes during the time that the employee needs to use it to express milk. Again, just note that the other requirements need to be met, so it needs to be shielded from view and free from intrusion by coworkers. And that means oftentimes that a lock or a signage or a combination need to be employed to make sure that the privacy is protected. It can also be a temporary space, and it only needs to be made available when it's needed. So every employee who's covered by the Fair Labor Standards Act does not have to proactively have a designated pumping facility until there's an employee who actually requires it. So that's intended to provide employers with flexibility, particularly smaller employers who are covered. And then there are some recommendations that the Department of Labor has stated are positive but not required. Those include access to an electrical outlet, a chair, and running water. Those aren't specified in the statute, but the Department of Labor's interpretation of the statute is that it would be a positive thing if those would certainly enable women to exercise their rights to express breast milk more efficiently and comfortably. There is a defense that is available in some cases of undue hardship, but the Department of Labor, we should note, has stated that the defense is intended to be very narrow. The defense is available only to employers who have fewer than 50 employees. Now, that number, that count of employees is itself defined very broadly, so it covers all of the employees' work sites if they have more than one. And it applies to part-time employees who are counted as well. So that is an expansive definition of what it takes to meet the threshold. And then to meet the threshold of being able to assert the defense in the first place. And then the definition of undue hardship is defined as causing the employer significant difficulty or expense when considered in relation to the size, financial resources, nature, or structure of the employer's business. So again, this language is intended to provide some flexibility for employers, particularly I think for smaller workplaces. But at the same time, the word significant difficulty is itself significant. It's not intended to be used just because the provision of the facilities for expression of breast milk might be inconvenient or cost a little bit of money. It has to actually be significant. And again, that significance question is going to be, the burden is going to be greater potentially on smaller employers than it would be on larger workplaces. And then finally, the question of whether providing the accommodation would cause an undue hardship is determined at the time the request is made, and it can change from moment to moment. So the defense cannot be applied prospectively ahead of time. It's not like an employer can say, well, we're a small business and therefore we're exempt altogether, because the analysis is really specific to the facts. It may, for example, be a hardship for an employer to provide an accommodation to, if it's a mom and pop retail, business, for their one staff person who works the cash register. But that analysis would be very different if they brought on an additional staff person, or it would be different for a person in a different role. For example, the bookkeeper who works for the same retail store part-time in the back office. So again, it's going to be a very fact-specific inquiry. So before moving to the anti-discrimination laws, I want to say just a word about state right to pump laws. There are over 20 state laws that protect breastfeeding rights at work. They're sort of analogs to the Nursing Mothers Act, and a lot of them predated the Nursing Mothers Act, and the Nursing Mothers Act was actually modeled on some of them. Many of these apply more broadly. They cover more employees and employers and workers. And in addition, so an example is the New York State law, which applies for up to 3 years after a baby's birth, and it applies to exempt and non-exempt employees. It doesn't matter whether the person is exempt under the labor laws for it to apply. And it applies up to 3 years after a baby's birth, as opposed to the Nursing Mothers Act, which only applies for 1 year after the baby's birth. As Kinkini mentioned in the beginning, the federal law does not preempt these state laws. So the stronger protections that are encompassed in these state laws is what would apply in any given state rather than the federal mandate. And then I'll just point to a good resource on this. There's actually two. One is the National Conference of State Legislatures, which many of you are probably aware has a compendium of breastfeeding state laws. That link is on the slide. And then also the picture that's on the slide here is of the ACLU's map, which we call Delivering Fairness, which it covers breastfeeding laws as well as pregnancy accommodation laws. So if you have questions about any of those, you can always refer to that as a resource. So moving to the question of anti-discrimination protections, as I mentioned earlier, the leading source of those protections is Title VII of the Civil Rights Act. Title VII covers businesses with 15 or more employees. I'll mention that many state laws cover smaller workplaces. So again, using New York as an example, simply because that's where I'm from. New York covers employers with 4 or more employees, so it has a broader sweep. And then state anti-discrimination laws are generally interpreted in the same way as Title VII, although there may be some differences in scope. Again, an example from New York, which, for example, covers more broadly disability rights. So the term sex includes pregnancy, and to understand how we got there, of course, this seems to be, it should go without saying that the term sex, when it comes to sex discrimination, includes pregnancy discrimination. But when it comes to the Supreme Court, that's not always true. So the Supreme Court, a little tour in history, the Supreme Court originally said that pregnancy discrimination was not included in Title VII's protection against sex discrimination. And that was in a case called General Electric versus Gilbert, which challenged an employer health insurance policy that excluded coverage of pregnancy-related medical care. And in that case, the court reasoned that this was not a violation of Title VII and the provision against sex discrimination, because there was a category of workers who was not pregnant, and that category included both men and women. So the court was dividing the world into two categories: pregnant persons and non-pregnant persons, which includes both men and women. And therefore, the court reasoned that a policy that excluded pregnancy-related care was not sex discrimination. In response, Congress pretty swiftly passed the Pregnancy Discrimination Act, which was an amendment to Title VII that defines the term sex in Title VII as including pregnancy and related medical conditions. And the Pregnancy Discrimination Act further states that pregnant workers must be treated the same for all employment-related purposes as other workers who are similar in their ability or inability to work. There's been some question about exactly what that second part of the Pregnancy Discrimination Act means when it comes to accommodations for pregnant workers, such as women who have lifting restrictions that impact their ability to do their regular job duties. And I'll come back to that in just a moment. So how does all of this anti-discrimination law discussion apply to breastfeeding and pumping at work? Well, initially there were some attempts to bring sex discrimination cases on behalf of women who needed accommodations related to breastfeeding. The early cases were related to the need for maternity leave or time off so that they could nurse their babies. And in those cases, the courts said that the term sex, even as amended by the Pregnancy Discrimination Act, did not include lactation. And the court reasoned that lactation is not a medical condition that's related to pregnancy and childbirth, even under the express language of the Pregnancy Discrimination Act, for a couple of reasons. In one case that I've mentioned here, the Wallace case, the court held that breastfeeding wasn't medically necessary, and somehow that meant that it wasn't a medical condition related to pregnancy and childbirth. And then in what is the leading case on this issue, which is the Martinez versus NBC case, the court held that because not all women breastfeed and there are no comparable men who need these types of accommodations, this doesn't count as sex discrimination. Now, the reasoning of these cases is completely backward and contorted, and relied on some of the same type of reasoning that Congress had repudiated when it amended Title VII in response to the Supreme Court's earlier decision about whether pregnancy was included in Title VII. So more recent cases, those cases are fairly old. The more recent trend is that finding that lactation is in fact covered under Title VII. The lead case there is EEOC versus Houston Funding, and that's a Fifth Circuit Court of Appeals decision that came out a couple of years ago. And in addition, the EEOC, which is the Equal Employment Opportunities Commission, which is the federal agency charged with enforcement of Title VII, has interpreted Title VII as covering discrimination against women because they are breastfeeding or lactating. The ACLU is working to get this reasoning adopted more widely in the courts, and we still need to educate courts on this point. And for that reason, we do work with experts like lactation consultants and pediatricians to educate the courts about the relationship between pregnancy and breastfeeding and the need to express breast milk. I'm going to quickly talk about the ways of showing discrimination. I don't want to get bogged down in too much detail, but I will give you a quick overview. The first way is known as disparate treatment, and the essential idea is that an employee is treated differently because of her sex intentionally by her employer. So examples include like the policy like the one in the Gilbert case that I mentioned that distinguishes between pregnancy and other health conditions. The policy on its face said pregnancy-related conditions are not covered. That's intentional discriminatory treatment. Another example would be an employer policy that, for example, pregnancy disqualifies a worker from doing a particular job, or an employer who expressly states that he is or she is firing an employee because they're pregnant. Now, these types of overtly discriminatory policies and smoking gun statements have become less and less frequent, thankfully, over the years as sex discrimination law has developed. But that doesn't mean that sex discrimination at work has gone away. So luckily, the law also recognizes that discrimination isn't always so direct and allows women to prove that they've been discriminated against or suffered discriminatory treatment by showing other types of circumstances that suggest that their employer has a discriminatory motive, is really taking the negative action against them because of their sex. So one example is job accommodations. So if employers give accommodations like extra breaks to a large number of other employees but not to breastfeeding women, this could be discriminatory, particularly if it creates a significant burden on women. And in determining that, the courts look to others who need those types of accommodations, like people with disabilities or off-the-job injuries, as comparators. I also want to mention sexual harassment as a form of intentional discrimination. Sexual harassment comes in two forms: the quid pro quo kind, which is essentially an example would be a boss asking for sexual favors from an employee on the threat of job consequences. The second kind is hostile environment, which is basically when there is so much harassment on the job related to someone's sex that it significantly impacts the employee's ability to do their job. And this is relevant here because we've seen cases in which women who are pumping breast milk on the job are harassed, particularly when they work in male-dominated industries. So the second way of showing discrimination is known as disparate impact. And that applies to business practices that are neutral on their face as to pregnancy, sex, or breastfeeding, but that have a disparate impact on women. They can still be challenged as discriminatory. And in such cases, the policies or practices will only be upheld if there is a business necessity and no feasible alternative that's less discriminatory. So an example of a employment practice with a disparate impact that's sort of relevant here is that courts have held that construction work sites that didn't have any restroom facilities had a disparate impact on female employees. And that's that case law can be applied in situations where there's a workplace that doesn't afford a woman a place to pump breast milk. And that's a theory that the ACLU is exploring right now. So why do we care whether the Title VII protections apply? There are a couple of reasons. The Nursing Mothers Act is a fantastic affirmative obligation where it applies, but it doesn't apply in all situations. It doesn't apply to all workers or to all workplaces. And as I'll discuss in more detail in a minute, it doesn't include a very strong enforcement mechanism unless there is wage loss associated with an employer's failure to comply or the employer takes retaliatory action against the employee. And finally, it also doesn't protect against straight-up discrimination. So the example where a woman discloses that she's breastfeeding and intends to pump breast milk, and the employer turns around and fires her right there on the spot. So we would like to be able to say that is sex discrimination and bring a sex discrimination claim based on that type of adverse employer action. But it's not exactly reached by the terms of the Nursing Mothers Act in all circumstances. And then I'll also mention that Title VII does have a stronger enforcement mechanism that allows women to go to court directly and allows for different types, higher damages and different types of damages claims, and also includes liability for sexual harassment, which may or may not be covered under the Fair Labor Standards, under the Nursing Mothers Act provision in the Fair Labor Standards Act. So I'd like to talk next about some of the options for when employers are not complying with their obligations under the law. The first and best option is always to negotiate with the employer and try and get them to comply, but that sometimes does not work. So what happens if it doesn't? Well, what do these laws allow you to do about it? First, I'm going to give some examples of what employer noncompliance can look like. These are examples that are drawn from cases that we have worked on where we've seen women facing discrimination related to the fact that they are breastfeeding or request accommodations for expression of breast milk on the job. So, the most straightforward case, again, is where a woman requests pumping accommodations and is flat out denied. Discrimination can also take other forms. In one case that we recently settled, our client, who was a worker in a hairstylist in a hair salon, requested breaks, and she was refused the breaks. The employer refused to give them to her, and instead he told her that she just wouldn't be able to work long shifts. So he cut her hours and ultimately fired her. And one of the reasons he gave was that work was no longer her first priority. So you see how the initial discriminatory act in failing to provide the accommodation sort of spirals and ultimately ends up in her termination. We had the case that I mentioned earlier, EEOC versus Houston Funding, where the woman was she was returning to her first day back after maternity leave, and was essentially told when she expressed her need to pump breast milk, she was told, your position has been filled. In the Ames versus Nationwide case, this is a case that was decided relatively recently. Some of you may have heard of it. The woman was Angela Ames was returning from her first day of maternity leave, desperately trying to find a place to pump. She was told that there was a 3-day wait to use the lactation room. And then when she went to her department head in increasing pain and desperation to find a place to pump, the department head handed her a pen and said, maybe you should just go home and be with your babies, and dictated her resignation letter. In that case, the lower courts ruled that this was not sex discrimination, in part based on the reasoning that in some cases men can lactate. So the court really contorted itself into knots to figure out a way to deny that this was sex discrimination. And then the court held that she had not been forced to resign, even though the letter of resignation was dictated by her boss. And unfortunately, in that case, the appeals court agreed that she had not been forced to resign, although it didn't address the other parts of the decision. So this is obviously a terrible decision. Unfortunately, it's not being appealed. And then other examples of sex discrimination, I'll just mention sexual harassment. Again, we've heard and worked with women who have faced harassment, including tampering with the location for pumping breast milk, placing grease on the handle of the door, and crazy glue in the lock of the room. One woman was said she was handed a bucket, a milk bucket, things of that nature, and that is a type of sexual harassment that is covered by Title VII. And then retaliation, which I'll talk a little bit more about, but in several cases, women have been assigned to less desirable shifts or had their hours cut when they have requested time to pump. So what can you do? What can women do in those types of circumstances? Under the Nursing Mothers Act, employees can bring claims privately themselves only in cases where they have lost wages or overtime in connection with the employer's failure to comply with the law, or in cases where the employer retaliates against them. Otherwise, if it's simply a case of the employer failing to meet its obligations, the woman asks for a place to express breast milk and the employer does not provide it or does not provide an adequate space, then the only recourse is for the woman to file an administrative complaint with the Department of Labor, which has the authority to enforce violations. So unless the woman has wage loss or suffers some form of retaliation, she doesn't have the ability to bring any kind of court case. She just can file a complaint with the Department of Labor. State law may have broader enforcement ability, so women may be able to bring claims in state court if their employers are not complying with the law. However, many state laws don't clearly state whether the individuals can go to court to enforce violations. So this is something that the ACLU has been working on, is trying to get some court decisions finding that those state laws are in fact enforceable. And we're using different types of theories, including the idea of bringing state tort claims. And one of the theories we use is called wrongful discharge in violation of public policy, the essential idea being that if there's enough of a public policy to promote breastfeeding in that state, that it protects the right to breastfeed at work, then women shouldn't be fired for actually attempting to do that. So I want to give just a little bit of information about what I mean when I say retaliation, what that means in the law. Especially because that's one scenario where there is a clear enforcement mechanism under the Nursing Mothers Act. The Nursing Mothers Act clearly states that if employers violate the law and retaliate against workers who engage in activity that's protected under the Act, that there is a right for them to go to court. And Title VII also has a similar provision. And the goal of both of these provisions is to make it so that employees are not afraid to come forward, that they are not afraid that they will suffer from retaliation from their employer. So retaliation applies to internal complaints as well as complaints outside to an agency. So if a woman complains to her HR department that her employer is not, her supervisor is not complying with the law, then that triggers the anti-retaliation provision. And if the employer then turns around and cuts her hours or writes her up or does some other negative action against her, she may have a claim for retaliation. An adverse action is defined as anything that would dissuade a reasonable person in a similar position from making or supporting a complaint. So the courts have interpreted retaliation and adverse action very broadly because of the goal of making sure that people are not afraid to come forward. So one example is that in one case, not under this law, but under Title VII, when someone's fiance got retaliated against, the court said that that could even count as retaliation against the employee, even though the fiance had not himself engaged in any activity related to the law. Just because if you know that your boss can retaliate against your fiance who also works there, that's going to inhibit you from filing a complaint. And then I'll mention that victims of retaliation can file either an administrative complaint or a private lawsuit seeking relief, and that includes a court order that the employer comply with the law, reinstatement to a position if they've been fired, lost pay, and then policy changes, which is really the broadest type of relief that can be ordered. So the court could order that the employer provide a lactation room and come into compliance with the law. In terms of anti-discrimination laws, I mentioned that they have some broader remedies. Under Title VII, employees can sue and get very broad relief in court, including back pay, any wages that they've lost, compensatory damages, and punitive damages, which are essentially intended to go above and beyond the person's actual monetary loss and act as a deterrent on employers for engaging in these types of prohibited activities. So the court or jury can award a much higher amount of damages to be paid under certain circumstances if the employer has really acted willfully badly in violation of the law. And then also injunctive relief, again, policy change or trainings or things of that nature that require the employer to take particular actions or change its policies in particular ways. Under anti-discrimination laws, there is an administrative requirement to file a charge of discrimination with the Equal Employment Opportunities Commission. I mentioned that's the federal agency that enforces Title VII. And the woman has to file it within either 180 or 300 days. That depends on a technical question of whether the state also has an agency that enforces an anti-discrimination law that prohibits sex discrimination. So the question of which deadline applies is not something that you should be expected to know. It's something a woman should consult with an attorney about. However, I will say that you should know that those types of deadlines apply and that they're strict. So women can't sort of sit and decide forever whether they want to move forward. They have to take action relatively quickly. And then the process of going through an anti-discrimination case can be lengthy and time-consuming. The first step being with the EEOC, which has to do an investigation, and then it issues a determination letter. It can also attempt to mediate the case to avoid a lawsuit, and then if not, that's the point at which a woman can initiate a lawsuit. The suit can be initiated by the EEOC itself in certain circumstances if it decides it's a case that it wants to take, or the agency issues what's known as a right to sue letter, which is given to the woman or her lawyer. And many state agencies often have similar requirements and processes. Often they do what's called cross-filing with the EEOC. So that's just something to be aware of, that these deadlines and processes may be the same for the state anti-discrimination agency. So that was a lot of information. I'll just go over a quick summary of the enforcement options if the employer is still not complying after attempts at negotiation. Those include filing a complaint with state or federal agencies. The Department of Labor Wage and Hour Division is the appropriate place to file for the Nursing Mothers Act. The State Department of Labor would be the appropriate place most likely for violations of state right to pump laws. And then the EEOC and state anti-discrimination agencies would be the appropriate place for anti-discrimination laws. Filing a lawsuit may or may not be an option, and that's something that, again, is complicated determination. Sometimes it takes me a long time to figure out whether it's an option, and I've been practicing law in this area for quite some time. So that's an area where the woman would be best served by encouraging her to consult with an employment lawyer. And then, you can also encourage folks to reach out to their local ACLU affiliates or the National Employment Lawyers Association, which is a great resource and runs a referral hotline. So moving to some strategies to support nursing moms, and then we'll leave some time for questions at the end. The first thing I'll mention is that when seeking accommodations, women need to come prepared. They need to ask concrete questions about how the company will accommodate them well before they plan to return to work to give the system time to work. They need to ask clearly for the accommodations they need and be prepared to provide documentation and negotiate alternatives. They need to, it's best if women ask for a meeting with their supervisor or the HR department to make sure the parameters are clear before they come back. And it never hurts to bring information, in particular a copy of the laws, particularly the Nursing Mothers Law, if that applies to them, and then helpful materials like the business case for breastfeeding if they think their employer might be resistant. And then the most important thing is actually to advise women to create and keep good notes, a paper trail of any communications with their employers. Memories don't always serve, and particularly I can speak from when I had first had my babies, you're not on a lot of sleep. It can be a very overwhelming time. So writing as much down as possible in order to preserve the record of what happened when, who they spoke with, what they said, because if worse comes to worse, they may need to remember all of that and be able to document it. I'll say a word on medical documentation. Employees covered by the Nursing Mothers Act should not be required to bring in a doctor's note. There's no requirement for that under the law. For those who are not covered by the Nursing Mothers Act, employers should only ask for doctor's notes if they require the same of others who are seeking accommodations for other medical issues or disabilities. So if you don't need a doctor's note to take a break, for example, to inject insulin, then you shouldn't need a doctor's note to take a break to express breast milk. But if you do for the one, then you may have to for the other. If there is a requirement of a doctor's note, it should, there are a few kind of magic ingredients that it should include. It should confirm the diagnosis of breastfeeding or lactation. It should clearly state the medical necessity to pump and express breast milk, and if possible, on a particular schedule, as well as the consequences of not doing so. That's something where we see a lot of doctor's notes fall short. And then it should specify clearly any other accommodations that are needed. For example, if a woman needs to be removed from particular duties or have her duties modified. So one example that we've heard is women who, police officers who have to wear a heavy bulletproof vest that in some cases has caused problems with lactation or even infection. And that is something that it should state in the note very clearly. And finally, a few Know Your Rights resources that I'll point you to. In order to exercise their rights, women really need to know what they are. And instead of trying to recreate this PowerPoint, you can refer clients to some of those resources. So here's a screenshot of the ACLU's Know Your Rights on Pregnancy and Breastfeeding at Work. The slide, that resource includes a lot of what I've just covered on this webinar. Here are a few more resources that are Know Your Rights materials. These are generally federal in their focus. They're not state specific. A lot of them focus on the Nursing Mothers Act, although many also mention state laws. The Department of Labor's website is particularly useful. As you probably all know, it has a great FAQ, a lot of different resources for both employees and employers on the scope and protections of the Nursing Mothers Act. And then I'll just mention a couple of state-specific resources. I know a lot of you on this call are probably involved in putting together resources in your own states. I mentioned the Delivering Fairness map. The U.S. Department of Labor also has a map of different protections related to pregnancy and breastfeeding. There's a good website called breastfeedinglaw.com, which also has a compendium of and discussion of the breastfeeding laws in particular states. And then, of course, all of the great materials that you all, I'm sure, are involved in putting together. Here are just a few examples. Illinois Legal Aid has one. The California breastfeeding laws is the subject of the middle one, and the New York laws as the focus of the third one. And here are just a few other resources. I'll mention a couple that you may not know about. The Job Accommodations Network is actually focused on employer accommodations for all kinds of different things, including disability, but they serve as a resource. They have a hotline that women can call on into, and they even help people negotiate with their employers in certain circumstances and provide resources to employers. So that's a really great one that you may not be aware of. I'll mention the Department of Labor request for information, which I don't know if everyone on the phone would have read, but it is worth perusing. It contains the Department of Labor's most detailed discussion of what is required by the Nursing Mothers Act. And then I'll just mention also the EEOC and the National Employment Lawyers Association are listed at the bottom. EEOC has some guidance that is available for individuals on their website. And they also issued a guidance related to pregnancy discrimination recently that covers some of the issues related to lactation. And finally, anybody who has questions can feel free to contact me, and I would be happy to take any questions.
Great. Thank you, Gail. This was a terrific presentation, and we have loads of questions. So I'm going to go with the first one that we heard is that we've received questions from employees who are forced to split their lunch breaks into 2 pumping sessions, and this leaves no time for the employee to eat. Is this acceptable under the law?
I should think not. You know, the law says that the breaks don't have to be paid, and the employers can require people to use existing breaks. But I think it would be difficult to argue that they had to take their entire lunch break and not get a lunch break. I think they could probably argue that that's not fair compliance with the law. And that's one where, you know, it might be worth talking to the Department of Labor about if the employer is not budging.
Okay. Our next one is about the defense of undue hardship, and doesn't the business have to prove the hardship to the DOL as well? I mean, do they have to apply for the exemption? So is the onus on the business?
The onus is on the business. That's absolutely correct. And, you know, it actually has to be officially granted by the Department of Labor. So I think that if an employer wants to assert that defense, they actually have to assert it in front of the Department of Labor. They can't just do it orally with the woman and say it's an undue hardship and leave it up to the woman to deal with.
Thank you. And then, is there I know you mentioned this in one of the examples you gave, but is there a quota for room space for breastfeeding mothers for a certain amount of employees? You know, if a business has 500 employees and only one room for moms, and that is full for most of the time, is there an obligation for the business to find more space?
Yes, absolutely. There would be an obligation, and we actually dealt with a case like that in Colorado where women were being forced to share space under circumstances that didn't guarantee their own privacy. They were being forced to, disrobe in front of their own colleagues while they were, and supervisors in some cases, while they were pumping in these tiny rooms. And, we were able to successfully advocate for the employer to add more facilities. So the law applies. It's pretty clear terms are that each time a woman needs the time and space to pump, the employer has the obligation to give that to her. So, while a certain amount of flexibility, I think, is in practice going to be required in terms of scheduling, women shouldn't be forced to wait undue periods of time such that it's disrupting their pumping schedule in a significant way. And if there aren't sufficient facilities to make them available in a private and secure way for women, then the employer is not in compliance with its obligations.
Thank you. And then we have a question. Do you have a good source or a template for a doctor's note as advocates? Is there something that we can share just so that we tell our moms to, make it a real solid note?
I don't have a model, and I think it's going to be a little hard to provide one. I have examples of doctors' notes that I have from cases I have worked on. So I think if people are interested in us developing something more broadly, maybe I can speak with USBC about that. But I think it's going to be a little bit difficult to give anything more than the general parameters that I included on that slide. I don't know if you can get back to it, Kinkini, but
sure.
The slide that said it should state the frequency and duration of the pumping, those were the general ingredients that it should include. So I would hesitate to give, exact language because each doctor likes to do their own, write things their own way. But as long as they include that information, it should be sufficient.
Yeah, thank you. And we have so many questions, time for two more. We've heard from moms who are forced to use their PTO for unpaid pumping breaks. And so there was questions about, like, in the law, are these breaks paid or unpaid? So our audience members wanted to know, but also for moms who are forced to use PTO for their unpaid pumping breaks, and which quickly exhausts their time off, and can they refuse to use PTO for this reason?
I would have to. I have to remind myself of that. Actually, I'll have to check and get back to you. The request for information may have something to say about that. The Department of Labor's request for information. I know that the Department of Labor has taken the position that employees should not be required to use their FMLA time for pumping breaks. I don't know whether they've taken a position on whether you can be required to use your paid breaks. I think that paid time off would be, my gut is that would be inappropriate. You're not required to take your sick days or sick time to do it because the requirement is on the employer to provide unpaid breaks. But I would have to check and see whether the department has expressed an opinion on that. There may actually be an answer to that in some of the materials they've put out, either in the request for information or their FAQs on their website. So I can check on that one.
Great, thanks, Galen. And I know we are out of time. We're just going to ask if there is a list of pro bono lawyers in each state that help with filing a suit. If ACLU has something like that, could we follow up with you afterwards and see if there are any resources that we might provide our state coalitions?
I think the National Employment Lawyers Association is the best place to start with that. Some of the attorneys on that list are not going to be pro bono, but they may agree to take cases on contingency. But at the very least, they may be available to do an initial consultation about, whether the person has a valid claim. So I would start with the National Employment Lawyers Association, which was listed on one of my last slides.
Great. And again, Galen, thank you so much for this terrific presentation. It's very timely, and there's a lot of momentum in the state and national to be doing this. So I'm going to move on to the next brief session that we have. There are updates from the CDC, and I'm going to invite Kelly Scanlon to give us updates from CDC. Kelly, you're on.
Yes, actually, Carol McCowan is giving the update today.
Sure.
Given that we're out of time, do we want to let people go on to the regional calls?
We can't hear you very well, Carol, but if you have short updates, we can, we can take a little bit more time into the regional calls. I think our audience really wants to hear from CDC.
Okay.
If you have.
I'll give two very short ones. I won't give all of the ones I have, but hi everybody. I just wanted to remind you that August 1st is coming really soon, and we're planning on releasing the 2012 breastfeeding rates, which are based on the 2013 and 2014 National Immunization Survey data. And we actually will be posting this August 1st on our website. So we're going to send out information to the states and to the coalitions when that is available. And I also wanted to announce something very exciting, which is that on October 1st, we will be releasing a Vital Signs MMWR, and I'm going to explain that in a minute. It's and this report's going to be on hospital support for breastfeeding. This report's going to be using data from the Maternity Practices and Infant Nutrition and Care Survey, or the NPN survey, and it's going to highlight the accelerated progress from 2007 through 2013 on the indicators of the 10 steps to successful breastfeeding. And just very quickly, because I threw in some acronyms, for those of you who don't know, the MMWR is CDC's Morbidity and Mortality Weekly Report. We like to call it our voice, the voice of CDC. And the MMWR is our primary way of getting, for scientific publication, timely, reliable, authoritative, accurate, objective, and useful public health information recommendations. The CDC Vital Signs that we're putting out is a monthly report that's released on the first Tuesday of every month, and it includes recent data and calls to action for important public health issues. Vital Signs includes an MMWR early release, a graphic fact sheet, a website, a media release, and social media tools. And we're really feeling very fortunate that our agency considers the topic of maternity practice as important as a Vital Signs release. So look for that release on August 1st. Now, I hope you're all ready for this one. This is our most important announcement. Dr. Kelly Scanlon has just been selected to be our permanent nutrition branch chief, and she will be replacing Larry Brummerstrom, who retired from CDC and went to work for WHO. And we are very, very excited to have Kelly as our new branch chief here in the division.
Wow, congratulations, Kelly. You absolutely great news, and wonderful to know you will be the new branch chief. And thank you for all those updates. Very helpful, very important. Great. I'm going to go very quickly over some of the USBC updates. We had elections for the 3 regions, Mid-Atlantic, Mountain Plains, and Midwest regions. So I want to introduce our newly elected regional reps. Kate Majestic from the Maryland Coalition is now the Mid-Atlantic region rep, and Rose Cohen, also from the Maryland Coalition, is the alternate rep. For the Midwest region, Shannon McKinney-Schubert from the Michigan Breastfeeding Network has been elected the coalition region rep, and Helen Demas was reelected from Illinois, has been reelected to be the alternate. So welcome. And from the Mountain Plains region, Brenda Bandy, who served as the alternate for her first term, was elected to be the rep. And Brianna Warner from North Dakota is now the alternate for the Mountain Plains region rep. So welcome to our new regional and continuing regional reps, and they will be reaching out to you soon. We have a lot of great updates and support for the coalitions coming in the next month, and you will hear from that. I want to express my deepest gratitude to the outgoing reps who've brought such great leadership and been such strong voices for their region. Chris Lundberg from the Midwest region, Kathy Logan from the Mid-Atlantic region, Jane Balcom also from the Mid-Atlantic region, and Charlene Burnett from the Mountain Plains region. Two very quick updates. We now have, as part of the landscape of breastfeeding support photo projects, we subcontracted with 8 breastfeeding coalitions to create a library of images to capture and showcase stories of breastfeeding support in action across 4 areas: community, research, healthcare, and employment, to represent the primary factors influencing mothers' infant feeding decisions. Now, this image gallery with over 10,000 high-quality, high-res images are now a free resource for the field, and the photos were featured in the Surgeon General's call to action. You can go to our website and access these photos. We also have we began to collect stories of breastfeeding support in action, and these submissions have become part of a bank of real-life stories compiled and displayed in real time, filtered into several different topics, so they could be used by USBC, our member and partner organizations, for a variety of reasons, for your campaigns, blogs, articles, anything. So as long as write to us, tell us what topic area you're interested in, and we'll send you the information. We USBC has expanded memberships with Board Source and Nonprofit Risk Management Center, and the membership benefits are available to all of you, the State Breastfeeding Coalition. So you'll have expansive lists, including webinars, publications, professional advice with both of these organizations. Again, you can access it via the Coalition's Learning Connection, so do be sure to join the Learning Connection. And coming very soon, we'll be having our first ever state networking calls for coalition advocacy. So be thinking about a couple people that you designate to attend these state networking advocacy calls. And we have very exciting plans for the virtual coalition's learning collaborative, including next steps for website and how you can use it much more to facilitate collaboration. So you will be hearing many more updates in the coming week. And that brings us to the end of today's session. Thank you again, Galen, for a great presentation, and thank you to you, our audience, for all you do to improve the lives of women, children, and families. Goodbye for now, and I look forward to having you all for our next webinar session. And now we'll go into the regional calls. So this webinar will end, and you all will need to hop onto your phone calls for the regional calls. Thank you again.